It's me. I'm Gordon Firemark. I am the podcast lawyer, entertainment lawyer, media intellectual property lawyer, and I wanted to come live and share with you a little bit because I was asked a question by by a woman who runs a website and inadvertently somebody on their team posted an image that they didn't get the rights to, and they're getting a demand from some lawyers and so on. And we talked a little bit about this, and unfortunately, these folks aren't in a position to afford to hire a lawyer. But I'm looking at the situation, so I wanted to share with everybody out there, all of you folks, a little bit of information. Before I do, though, I have to tell you my little disclaimer, and so I'm going to put that in the comments, and I'm actually going to put it on the screen here. I'm not your lawyer. Just because I'm talking about this stuff. This is information, no attorney-client relationship, not a substitute for hiring a lawyer to represent you, those kinds of things. But I wanted to get out here and just share this real quickly. I've got a few minutes before I got to go pick up the takeout we're having for dinner tonight, so I thought I should. So I told this person, look, before you do anything else with this law firm or these people that are demanding money from you for the use of this photo. Look, you took the image down already. That's been there, done that. But the attorneys they're demanding money. They want damages. And I said, well, before you give them anything, before you even talk to them about anything, you tell them they've got to prove to you that they own a copyright. And the way they should do that is probably to show you the registration. And so she apparently went back to them and did that. And the attorney said, it's not yet registered with the Copyright Office, but there's no legal requirement that an image be registered for an individual to have rights to their own materials. That's a true statement, but it's not a complete statement. Copyright exists in the image as soon as it's saved in tangible medium. Yes, 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 that's true. But if you don't own the copyright, you don't get to sue people about it, and you don't get to claim money from people about it. In order to make a claim for copyright infringement, you have to prove that you own the copyright. The thing about it is that if you're not the person who took the photograph, you probably don't own the copyright unless you are the employer of the photographer who took the photograph, and they're your employee as a photographer. So that's point number one. Got to prove they own it. If they don't show you proof that they own it, you don't deal with them. They're going to have to prove it when they go to court, and they might as well prove it to you now. So the way they can prove it is either show you the registration or explain to you the circumstances, show you that the person who took the photo was an employee, or that there's a written contract transferring the ownership to them. It doesn't have to be the registration, but they got to be able to show you something. They got to explain and lay that out in a way that makes sense, and they got to be able to prove it. Next up, this lawyer says, therefore the copyright exists regardless of whether the image is registered or not. True. The only reason why our client would consider registering the image now is for litigation purposes, which we're trying to avoid, and the reason for trying to resolve the matter amicably. Okay, great. All of that makes great sense, but there's a problem, okay? Here's the thing. They want to recover damages. So what they're not telling you is that if there was no registration before the infringement occurred, and if it wasn't done in a timely fashion, usually within 3 months of the first publication of the image, then they can't collect statutory damages. And they can't collect attorney's fees if they sue and win. So what they have to do then is not only prove that they own the copyright and that it was copied, but also prove their actual damages, their actual out-of-pocket losses. So if they can't prove, how much they've lost, that's a problem. So you can request evidence about what the value of the damages is. How are they planning to calculate that? If they've demanded a number, they should be able to tell you how they calculated it. If they're saying, hey, you infringed our copyright, and normally when somebody comes and uses that image, that particular image, they pay, we require them to pay $1,000. Then if they can show you evidence that they've routinely collected $1,000 for the use of that image, not just once, but routinely, then that's the measure of their damages, right? But if they can't prove that, then it's anybody's bet or anybody's guess what a jury might actually grant. Actual damage, you have to prove how much you've lost. So without the early registration of the copyright, no statutory damages. If there was an early registration, statutory damages range everywhere from $750 per infringement up to as much as $150,000 per infringement. But in a situation like this where there's no registration, they're not going to be able to collect very much at all unless they can prove, hey, this infringement, that what a license for this image would have cost had you asked and been granted permission, and they better be able to prove that they've actually received that amount from other licensees in the past. If otherwise, just, it's just their guess. They're saying, this is how much I want. And the judge in the court's not going to do that. So I guess my point is, if you are confronted with one of these demands for using an image or piece of music, for that matter, anything, make sure that they prove to you that they are actually the owner. It's not enough just to say, hey, it's ours, we own it, we want. Because a lot of times the company that's contacting you isn't really the owner. In this instance, I'm pretty sure that the photographer who took the picture was a freelance photographer. And so unless that photographer signed over the copyright to this particular agency, this company, then the company doesn't even own the rights. They may have the right to post it on their internet and do things like that, but my guess is that they don't have all the rights they need in order to bring this in. So there's lots of stuff that goes on here, and I just feel like a lot of these companies are sort of extorting their way into payments, and these law firms that are doing this, they will tell you partial half-truths, but they won't be completely candid about it. So don't get taken advantage. If you taken advantage of, excuse me, if you are confronted with one of these things, reach out to a lawyer, talk to a, before you pay thousands of dollars in damages and things like that. Make sure you talk to somebody who can help you get, the clearest picture of things. If they're asking for a few $100, yeah, it's cheaper to pay. Make sure they sign over a complete release that promises that they're signing over all, that they own everything and that it's the complete final release of all claims. But if it's into the $1,000 or more, it makes sense to talk to a lawyer, get some advice, and maybe even have that lawyer handle the negotiations on your behalf, because it'll save you money. So that's all I wanted to say today. Hope you're doing good. If you're watching and you have a comment, say hi. Otherwise, I guess I'll sign off. So thanks for today. Thanks for being here, and I hope this has been helpful. Don't just pay. Don't just admit any liability. Make them prove their case. Thanks. See you soon.